Today there are so many federal crimes on the books, either directly in the statutes or in regulations which carry a criminal penalty for violation, that I think we should almost start over, obviously leaving on the statute books those things that are real crimes, such as theft, fraud, other kinds of interstate crimes or crimes that otherwise would be in the federal jurisdiction, but not having regulations that carry the power of crime. I think that, if anything, it's important that if something is serious enough to send someone to prison, it ought to be set forth in a statute passed by Congress and evaluated as to the necessity of a criminal penalty, rather than simply something that is promulgated by some regulatory agency, the violation of which is then by statute made into a crime. We need to have crimes that are limited to those things that are serious violations against the public safety, and leave other kinds of conduct which may have an effect either economically or environmentally or otherwise to civil penalties, administrative actions, and handling and remedies such as that.
Solving the overcriminalization problem is a tough nut to crack. It requires a huge amount of public education. I think for many people there is not understanding that criminal liability is not the only solution. Civil liability is probably not something that most people are familiar with. People may not understand that there are already remedies for many of these problems at the state and local level, and so there's no need for a criminal solution as well. And people may not appreciate the constitutional element of that issue, the federalism element of it. There's also a problem, frankly, in both Congress and the executive branch with understanding the constitutional and policy impetus for not expanding criminal liability at every turn. Take, for example, theft. One of the reasons that federalizing every crime causes a problem is that when everyone is responsible, nobody's responsible. So if theft becomes a federal crime, the local police can say, oh, that's not my problem. And the FBI can say, well, why should I be enforcing theft laws? Nobody enforces the law. So it's important to have clear delineation of who's responsible for what.
We recently did a study of all of the criminal proposals from the 209th Congress. And what we found was that the majority of them did not have an adequate intent requirement. Sometimes it varied, the different elements had different intent requirements in the same statute. We found that for the most part, they weren't even being reviewed by the judiciary committees, which are the committees that are supposed to pass on our criminal law. We can't have that. We've got to come up with a procedure to make sure that these things are looked at very carefully. We should have, as a matter of policy, a default mens rea. That's a fancy, that term mens rea, it's a fancy Latin word that they teach you in law school. What it is that's the mental component. That's the mindset that makes somebody a criminal, an intentional actor. And we've got to make sure that those are strong requirements so that we don't sweep people up who aren't willfully or knowingly breaking the law, but are innocently just going about their business.
I think, again, when legislators make laws, they have to be cognizant of the fact there could be unintended consequences, and they have to make sure those laws are clear, that they have a culpable mental state, so that conduct that's innocent, that is a complete accident, that someone did not intend to commit a crime, that prosecutors don't have the ability to just indict almost anyone and oftentimes get a plea bargain, because if the law is very vague, someone may worry that they will be found guilty and could be sentenced to a long prison term. And so even though they didn't have a culpable mental state, didn't have any intent to commit a crime, they may agree to a plea bargain. So when you have laws that are excessive in terms of their scope, in terms of their punishment, it really gives prosecutors they wield that sword to get a plea bargain, even where someone may be innocent, may agree to a plea, because they don't want the expense and the risk of having that prosecution go forward. So it's a balance. You need some prosecutorial discretion, but you absolutely have to make sure that your laws cover only those conduct that really should be criminal, and then within that are very clear about what's legal and what isn't.
Well, I think legislators need to think about four things whenever they are considering creating new crimes. First of all, simply ask yourself whether or not it should be a crime, whether or not it's the type of activity that historically and traditionally we've thought of as a criminal act. Secondly, Ask yourself whether or not you've included the appropriate mens rea requirement in the statute you're drafting. Thirdly, ask yourself whether or not it needs to be a crime at this level. If you're a federal legislator, for example, do you really need a federal crime for it, or are there already state and local statutes that govern it? And fourth, if it does need to be a crime and you have included the appropriate mens rea, and it does need to be a crime at that particular level, ask yourself what the appropriate punishment is. Maybe incarceration, for example, is not actually the right punishment.
One of the things we have to do to change the status quo and step back from this overcriminalization of business regulation and the conduct of individuals in our country is to basically change our cultural and political expectations about it. And one of the best ways to do that, in my view, is to return to fundamentals. One of the practical things that I think we could do is Congress could sunset vast arrays of federal regulations and the criminal enforcement mechanisms that go with them, thus forcing themselves to go back and re-examine whether we really need those provisions at all, and if we do need them at all, can they be scaled back and minimized so that we reduce the effect of this overcriminalization. And the reason we need to do that is equally important. Overcriminalization and overregulation of business inhibits economic activity. And when economic activity is inhibited, the country can't grow, jobs can't be created, companies can't thrive.
Any statute that contains a criminal penalty ought to go through the Senate Judiciary Committee or the House of Representatives Judiciary Committee before it is voted on by the entire body, to have this kind of scrutiny about whether this should be a crime, whether it's necessary, whether it's just and fair, so that there is one body within the Congress, even though a law may originate in some other committee, would have kind of a special scrutiny to be sure that a particular act should be forbidden and made criminal, rather than simply passing a law which has a criminal penalty because some particular group feels it's an important topic, or because there's a great deal of attention.
I think that it's important for business, individual businesses and business organizations to engage with the government, because as well-meaning as a government agency may be, it may not be possible for them to understand the effect of their regulations or their actions on business if business isn't willing to come forward and explain it. The Chamber of Commerce, for example, has committed a lot of resources to educating the public, educating the government about the effect that regulation has on business and the effect that it has on their ability to hire people and restart the economy.
It's hard to imagine a system where we go back to the balance that we had 250 years ago, in part because it's very hard to unwind machinery once it's built. But I think we can get closer to the balance if we start with the recognition that there are too many crimes and they're not well defined enough. And then we move to the recognition that maybe it's not always a good idea to add more and more investigators and more prosecutors. Prosecutors and investigators do good work. They're good people. They want to get at the bad guys. But I think if we can get to a system where they're given a lot more guidance as to who the bad guys are and what sorts of things ought to be done to them, and we get away from this idea that we ought to just expand the federal criminal code forever and expand the number of investigators, expand the number of prosecutors, that will return more to the system that we had back at the time of the framing.
When I think about the various groups that are coming on to some of the briefs that we're doing, when I think about the recent hearings by the House Judiciary Committee, really, and we got to see this, we got to see hearings both before and after the Congress changed from, in the most recent cycle, from Democrat from the Democratic control to Republican control. It was very interesting to see both the chair and the ranking member coming together on their concern about how Congress is drafting these laws and how we're seeing this overcriminalization phenomenon. And I think what it shows is that when you have clear injustice, then the arc of injustice bends to the point where left meets right. And that's where we are in this country now. We are beginning to see a consensus that we've gone too far with criminalization.